Hi, I'm Elizabeth Khalil from the FDIC's Division of Depositor and Consumer Protection, and I'm here with my colleague Larice Brown. In this segment, we'll discuss some questions and issues the FDIC has been hearing from our supervised banks as they continue to implement the mortgage servicing rules.
One question our banks have been asking is what the term delinquency means in connection with the 120-day pause or dual tracking requirement. As discussed earlier, the 120-day pause provision prohibits a servicer from making the first notice or filing required for foreclosure unless the loan is more than 120 days delinquent.
Based on informal oral guidance from the CFPB, servicers should look to common principles of statutory interpretation, as well as to state law or contracts, for the meaning of undefined terms, such as delinquency. Another question we've been hearing is whether state servicing rules are preempted by the federal mortgage servicing rules.
The rules specifically say that state laws on transfer of servicing notices and disclosures are preempted. RESPA continues to generally preempt state laws that are inconsistent with RESPA. A servicer will be considered to have complied with the provisions of a state notice requirement where the servicer has complied with the federal mortgage servicing transfer notice requirements to a borrower at the time of application for a loan or transfer of servicing of a loan. It's important to note that the CFPB's commentary states that RESPA and the servicing rules should not be construed to preempt the entire field of regulation of the practices covered by RESPA or Regulation X. This means that servicers must still comply with state servicing laws that cover different subject matter than these federal rules or that are not in direct conflict with the rules. Banks have also asked which loans are covered or not covered by the adjustable rate disclosure requirements.
The CFPB has made it clear in its official commentary to Regulation Z that certain loans are not ARMs, even if their interest rates or payment amounts can change. Thus, mortgage loan transactions, if structured as fixed-rate loans and not as adjustable-rate mortgages based on an index or formula, are not subject to the ARM loan disclosure requirements. Examples include graduated payment mortgages or step-rate transactions, renewable balloon payment instruments, and shared equity loans. Note that modifications under the Home Affordable Modification Program, or HAMP, are generally considered step-rate loans. Here's another common question from banks. What if we receive an error notice or information request from someone other than the borrower? How do we handle such requests?
The CFPB has clarified that servicers must treat an error notice or information request submitted by an agent of the borrower as though it came directly from the borrower. In such a situation, though, it's important to determine whether this person is indeed an agent of the borrower. The rules commentary states that a creditor, assignee, or servicer may take reasonable measures to verify the identity of the consumer's agent or representative. It also states that the response period does not begin until a request is received from a verified party. A verified request sent by a borrower's attorney or other representative typically will include an authorization signed by the borrower. We've also been asked whether a bank is responsible for the actions of its sub-servicers.
The answer is yes. As a general matter, banks are ultimately responsible for complying with all applicable laws and regulations, including the servicing rules, whether they conduct the activity directly or through a third party. So, bank servicers are expected to oversee their business relationships with any sub-servicers in a manner that ensures compliance with the servicing rules and other applicable laws and regulations. Remember, too, that the number of mortgage loans a sub-servicer is servicing can also affect the bank's status as a small servicer. Banks have also asked whether flood insurance is covered by the servicing rules.
As previously indicated, flood insurance required by the Flood Disaster Protection Act of 1973 is not covered by the servicing rules provisions on force-placed insurance. A couple of other examples of the types of hazard insurance that are excluded from the force-placed insurance rules are hazard insurance obtained by a borrower but renewed by the borrower's servicer as described in the rules, and hazard insurance obtained by a servicer and renewed by the servicer at its discretion if the borrower agrees. Banks have also asked, when a borrower calls our bank to say there has been an error, Do we have to tell them to send their request in writing?
The answer is no. The bank does not need to require that the error request be in writing. The rules themselves do not require the notice of error from the borrower to be in writing. Therefore, a bank could choose to accept error notices orally or over the phone without conflicting with the servicing rules. However, the servicing rules require a servicer to comply with the formal rule requirements when it receives a notice of error from a borrower in writing. Banks have also asked whether a servicer must still send the disclosures regarding force-placed hazard insurance if the servicer is a debt collector under the Fair Debt Collection Practices Act and the borrower has sent a written cease communication request to the servicer.
The answer here is yes. The CFPB has clarified that a servicer will have no liability under the Fair Debt Collection Practices Act if it complies with the mortgage servicing rules regarding error resolution, request for information, force-placed insurance rules, loss mitigation rules, the initial interest rate adjustment disclosure for ARMs, and the furnishing of periodic statements. Note that a servicer that is a debt collector under the Fair Debt Collection Practices Act that has received a written cease communication request from the borrower is exempt from complying with requirements for both early intervention and notice of interest rate change for ARMs with corresponding payment changes. See the rules for details. We've also heard the question, if our bank only originates HELOCs, do the mortgage servicing rules apply to us?
Yes, the mortgage servicing rule requirements for providing payoff statements apply unless an exception applies. We've also received the question, our bank is in a rural area. Do the mortgage servicing rules apply to us? The answer is yes, if you otherwise are subject to the servicing rules. There is no rural exception in the servicing rules. The geographic location of the bank or of the property securing the service loan does not matter when determining whether your bank qualifies for the small servicer exemption.
We hope you found this segment helpful in clearing up some common questions about the mortgage servicing rules.
In the next segment, we'll discuss some best practices for complying with the servicing rules and give you some tips for incorporating servicing rules compliance into your compliance management system.